Good afternoon, everyone. Good afternoon, you're right, good afternoon. My name is Jose David Saldivar, and I'm the director of the Center for Comparative Studies in Race and Ethnicity and a professor in the Department of Comparative Literature. I'm delighted to welcome all of you to this year's Anne and Lauren Kieve's distinguished lecture. Our Kieve lectures tend to be something of an event in our field. The field being not only the comparative study of race and ethnicity, but also multiracial, cross-racial studies impinging on America and the world. The Kieve lectures have impact. They cause discussion and they provoke debates. This year's lecture, however, seems to me unusually well motivated because we not only have one great speaker, we have two. So it's going to be, I think, a really interesting format. Each year, the Center brings to Stanford a notable scholar, writer, or public intellectual to deliver a lecture pertaining to vital issues relating to race, ethnicity, and racism more broadly. This lecture is endowed by the Anne and Lauren Distinguished Speakers Fund. Anne and Lauren hope that the lecture will help us think through public issues related to the place and space of race and ethnicity. And we will welcome them when they make it from San Francisco. The Anne and Lauren Kieve Distinguished Lecture is one public aspect of CCSRE that seeks to address social, cultural, and global questions about race and ethnicity in research and teaching, and to motivate our students and colleagues to take up these questions as engaged and activist citizens in the remaking of democracy, as our speakers have so eloquently written about. Over the years, we assembled a range of thinkers, writers, and artists to address the problems and challenges of our cross-racial multiculture. And today, the Anne and Lauren Kieve Distinguished Lecture is one of the most prestigious lectures at Stanford University. Our past speakers have included Drs. Lani Bunch, Melissa Harris Lacewell, Glenda Carpio, Lawrence Bobo, Claude Steele, and the Pulitzer Prize-winning novelists N. Scott Momaday and last year's speaker Junot Diaz. To introduce our speakers and moderator this afternoon, I will now ask my colleague, Professor Prudence Carter, Director of CSRE's Rick's Re program and a professor in the Graduate School of Education, to come to the podium and make a formal introduction.
Thank you very much. Thank you very much, Jose David. It's a very symbolic day for civil rights. For those of you who may not be aware, today is the 59th anniversary of the Brown versus Topeka, Kansas Board of Education decision, and we chose this date for the Kieve lecture intentionally. So I just want you to know, to acknowledge that which we do here at CSRE. And it is really a pleasure for me to introduce our two speakers and our moderator for today. I am particularly pleased to introduce these two because they model for me and exemplify for me what it means to do scholarly collaboration. And just watching them over the last day or so has been a treat in many ways, because they exemplify what it means to debate, not always agree, right? But at the same time produce rich and deep and provocative ideas for us. And to keep the conversation going. And that's what we hope we'll do as they speak and as you, the audience, engages with them today. Our guest speakers are Professor Lani, Guinier, and Gerald Torres. Perhaps the two of them are most known for their co-authored book, Miner's Canary: Enlisting Race, Resisting Power, Transforming Democracy, which was published in 2002. When it was published, Publishers Weekly described it as one of the most provocative and challenging books on race produced in years. Let me just say a little bit about both of our speakers individually. And this is probably one of the few times that I have the opportunity to tell her how much I admire her incisive, analytic, deep commitment to thought, to social justice, and just her incredibly warm spirit. I love the way your mind works, Lani Guinier, and you have modeled for me tremendously what it means to be a committed scholar, thinker, and an advocate for a better society. Lani Guinier is the Bennett Bosky Professor of Law at Harvard Law School, and she is the first woman of color to be tenured at the Harvard Law School. A graduate of Radcliffe College and Yale Law School, Professor Guinier worked in the Civil Rights Division at the U.S. Department of Justice and then headed the Voting Rights Project at the NAACP Legal Defense Fund in the 1980s. She has published many scholarly articles and books, and I'm looking forward to her forthcoming book entitled, I hope this is still the title, The Tyranny of the Meritocracy: How Wealth Became Merit, Class Became Race, and higher education became a gift from the poor to the rich. And this will be forthcoming this year. And you'll tell us when that's coming out. That's a great title, right? In her scholarly writings and op-ed pieces, she has addressed issues of race, gender, and democratic decision-making and sought new ways of approaching questions like affirmative action while calling for candid public discourse on these topics. Professor Guinier's leadership on these important issues has been recognized with many awards, and she is the recipient of 10 honorary degrees from various colleges around the nation. Now, as the saying goes, birds of a feather flock together. And Professor Gerald Torres is Professor Guinier's fellow foot soldier for social justice through law and democracy. He and Professor Guinier, as I said, they just model very well what collaboration between scholars, friends, and thought leaders look like. A Stanford alumnus, Gerald Torres is the Bryant Smith Chair in Law at the University of Texas, Austin. Also a graduate of Yale Law School, he is a leading figure in critical race theory and an expert in agricultural and environmental law. Professor Torres is also the former president of the Association of American Law Schools. He has served as a Deputy Assistant Attorney General for the Environment and Natural Resources Division and the U.S. Department of Justice in Washington, D.C., and as counsel to then U.S. Attorney General Janet Reno. He, too, is a prolific legal scholar, having written a number of critical and important legal arguments, articles, and books. And in 2004, he was honored by the Mexican-American Legal Defense and Educational Fund for his work to advance the legal rights for Latinos. Welcome back to the farm. Our moderator for the afternoon is one of our own, too, Professor David Palumbo-Liu, who is the Louise Hewlett Nixon Professor of Comparative Literature and by courtesy English. He is a social and cultural critic, a literary theorist, and an expert on East Asian and Asian Pacific American studies. Another prolific author, Professor Palumbo-Liu is most interested in issues regarding social theory, community, race and ethnicity, justice, globalization, ecology, and the specific role that literature and the humanities play in addressing these issues. He is the founding editor of Occasion, Interdisciplinary Studies in the Humanities, and he blogs for Truth Out in the Boston Review. He's also a contributing editor for the Los Angeles Review of Books, and he serves on the Academic Steering and Advocacy Committee of the Open Library of the Humanities and the Advisory Board of Bibliotech. So you see, we're going to have before us today three really incredible and extraordinary individuals and thinkers. Let me just tell you a bit about the format before they begin, and I welcome them to the stage. Professors Guinier and Torres will dialogue for about 40 minutes. Then there will be about 10 minutes of dialogue with Professor Palumbo-Liu, and then we will open it up to you, the audience, for questions and answers. It is my highest honor and pleasure to welcome all three of them to the stage. Welcome.
Thank you, Kieve. First of all, good, it's on. It sounds loud to me. I hope it's not as loud to you. First of all, I want to thank all of you for being here this afternoon. I'd like to thank the Kieves. I'd like to thank my colleague, who I've known since he was a junior in college, Jose David Saldivar, and when he was a junior in college and I was starting law school, we conspired to produce a literary magazine, which we will not share with anyone at this point. Suffice to say, we thought we were smarter than we were. In any event, it's really good to be back to Stanford, and it's really good to be able to give this lecture on the anniversary of Brown against Board of Education. The title, The ABCs of Racial Literacy, begin for us, at least in the modern discussion, with Brown. Brown against Board of Education helped define the grammar of race by reducing it to a formal problem of racism defined by classification by race by the government. And if the government would not classify people according to race, then there wasn't a problem. Now, well, there's still a problem of people with bad hearts. There's a problem of people with bad intentions. But the problem of the social distribution of goods that are controlled by the government really was just a problem of racial classification. So rather than rooting the remedy of unequal educational opportunity that the students had in the social conditions that produced that inequality, and as a way for the nation to take responsibility for its racial history, it instead rooted it in a formal relationship. Racial liberalism, then, of which Brown against Board of Education is a signal example, is about formal inequality. The government must be neutral unless there is a specific racial injury. If there's a specific racial injury, then the remedy is limited to the curing of that injury. But it also has to be produced, when it's not the government, by a specific perpetrator who has violated some other norm. So that the problem of racism, then, within the definition of racial liberalism, right, is the problem of the bad heart. It's the problem of the bad actor. It's not the result of good people or people of goodwill living out their lives through the results that the institutions of themselves would produce. So the institutions of themselves would produce the inequalities through no evil intention or bad intention of the individual people themselves. If you could find the bad person, then you could make the remedy. But the institutions themselves, where they weren't implicated in the logic of Brown, were by and large immune. This includes, of course, the unconscious structures that all of us bring to our daily lives. And it stopped an inquiry into how those ideas are created. Now, when you go back to Brown and think about Brown, right, one answer to the problem that was challenged in Brown against Board of Education would have been to adopt a simple equalization remedy. And in fact, there were those in the African American community who argued for that, which is what we need are the resources brought to the black schools. We need the black schools to be funded. We want to be able to provide an education on an equal basis with those in the white schools. In fact, even the Reverend Martin Luther King, when asked about education, reportedly was, as he put it, concerned about giving over young black children to white teachers. But since the problem was the illegitimate classification, we see in Brown logic that takes us from an attack on separate and unequal institutions in the South to parents involved, a more current case, and we'll talk about that a little bit later. Now, in Texas, right, you had additional problems, right? You had not just black schools, right, and you had brown schools, or you had Mexican schools. And so when the logic of Brown led people to challenge Mexican schools, the logic of race, or the idea of race, could intervene to delegitimize the complaint. Because the answer in Texas was that Mexicans aren't black, that is, they're not really a separate race. And so any discrimination that they are experiencing is discrimination on the basis of their class position. And so in Delgado against Bastrop, one of the early cases, the state of Texas did the natural and logical thing. It took Mexican off the name of the school. And rather than being the Bastrop Mexican School, it was just the Bastrop School. And the fact that the school was now, the students were there suffering the same inequality, but it was an inequality that the government was not responsible for remedying, the inequality that was based in class. The black schools, on the other hand, that was illegitimate. And so just outside of Boston, when forced to integrate, they did what they did across the South in many places. They brought black students into the white schools, and in a particularly egregious moment, responded to the court order by bulldozing the black school down to the ground without emptying it of the trophies and the yearbooks and the photographs. So that the message of integrating the schools was clear. We'll do it, but we're not happy about it, and you're not going to be happy about it either. And so what we're going to do today is to take the logic that those early cases produced for guiding us to think about race and ask whether there is a different way to become racially literate, or whether we're commanded by the logic of Brown and the grammar, the legal and racial grammar of Brown, to think about race in that particular way.
So Professor Torres just talked about an alternative way of thinking about race that he named racial literacy, and I want to try to develop that concept a little bit more so that you see the contrast between what we're calling racial literacy and what others in the past, particularly in the period after World War II, called racial liberalism. And so, as Gerald has already explained, the idea behind racial liberalism, which was considered to be a quite favorable view of racial injustice, favorable meaning that it got to the point, but the assumption was that racism was an individual failure. So if people were racist, that's because they were bad people. That racism was irrational and would surrender to logic and interpersonal contact. So you could just talk somebody out of being a racist if you were being clear and logical. That racism in some way was limited to bad people who had bad hearts. And I don't mean that they had a heart attack. I mean that they were unsympathetic. And therefore, the response was to educate individual black people to be able to withstand this unfairness, and by advancing to prove, by virtue of their individual success, that racism was inappropriate. And what I would like to do right now is to suggest an alternative view of the work that race needs to do. And that's what Professor Torres and I have been calling racial literacy. And racial literacy is not the same as racial liberalism. So whereas racial liberalism located the problem in individual children, for example, in the Brown versus Board of Education decision, the Supreme Court talked about the experience of black children in the North and the South based on Kenneth Clark's doll studies. And Kenneth Clark had suggested that when shown two dolls, one black and one white, now when I mean dolls, so they're painted black and white, they're not people, that when confronted with these two dolls, that the black children preferred to play with the white doll. And he suggests that shows the damage that racism has done on black children. The problem with Kenneth Clark's findings, however, is that the children who were most likely to prefer the white doll were the black children in the North who were going to integrated schools. So the children in the South, when seeing two dolls, not using perhaps what we would consider healthy language, but they would say, that's a nigger, I'm a nigger, that's the doll I want to play with. But the way that this psychological test was promoted and the way in which people think of it in retrospect is that it was the black kids in the South who wanted to play with the white doll and therefore had a very low self-image, when in fact it was the black kids going to the integrated schools that had that particular view. So what does that suggest? Well, it suggests that racism was not simply a problem with an individual, but it was a function of a culture. And that that racism, according to racial liberalism, would just surrender when you showed logical arguments as to why racism didn't make sense. And that racism was limited, as Professor Torres said, to bad people with bad hearts, and I don't mean that they were about to have a heart attack, and that the response was therefore to focus on the individual and fix that individual. That was the concept that preceded Brown. And the concept that Professor Torres also just talked about is an alternative that we've called racial literacy. And it's an alternative that I think is perhaps best illuminated by what happened 3 years after Brown, when Little Rock, Arkansas was selected as one of the first communities that was going to desegregate its public schools. And most of you are too young to have been aware of what was happening in 1957, but for those who were there, or for those who have watched any of the Eyes on the Prize documentary, when the black kids, and these are 9 well-groomed, prepared black kids, they had rehearsed what they were going to be doing, trying to enter Central High School. And there was just a terrible response from the community of parents and students who had been going to Central High School for most, or for predominantly white high schools for most of their childhood. And you see these faces, and the adults in particular look as if they're not only angry, but they are out of control in terms of their anger. And you think, well, they must have just been bad people, right? That's the idea of racial liberalism, that racism is a function of bad people with bad hearts. But what people don't tell us about Little Rock is the fact that at the very same moment that Central High School had been selected as the place for integration to happen, the upper middle class and the elite whites in Little Rock had built a new school called Hall High School that opened, coincidentally, in September of 1957, at the very same time that the black kids were being groomed to enter Central High School. Now, what's the significance of the elite white community in Little Rock starting its own school? Well, it meant that the kids who were left back in Central High School, left back meaning remaining in Central High School, were white children whose parents were not upper middle class, whose parents were not members of the elite. And so for them, they saw the leaving of the children of the doctors and the lawyers as downward economic mobility, because they were losing the opportunity to fraternize with people who were much better off and perhaps would give them leads in terms of jobs or would mentor them and give them suggestions. And instead, there were these 9 black children, well-dressed, but they had nothing to offer the whites, at least from their perspective. And so there was this mayhem. Well, a sociologist whose name is Beth Roy wrote a book in the 1980s, so this is now 30 years after Little Rock, called Bitters in the Honey. And in that book, she interviews the children, the white children who had been at Central High School when it was first integrated. And she was amazed to discover that the parents of those children, as well as the children themselves, were still furious about what had happened at Central High School in 1957. Now, this is 30 years later, and they are still thinking about something that happened that was historic. The culture had shifted between the 50s and the 80s so that you now actually had black people getting elected to Congress. You had a black senator in the United States Congress. But what they focused on is this idea that black people had somehow stolen the American dream from them because they were no better off in the 1980s than their parents were or than they were in the 1950s. Now, this to me, at least, suggests that we focus intently on the nature of the American dream. Because the premise of the American dream is if you work hard, play by the rules, you will succeed. These people that Beth Roy was interviewing had worked hard, they felt they had played by the rules, and they were not succeeding. So they had no explanation for their failure in terms of the way in which we articulate the American dream more generally, except for one, right? They did have one explanation. Those black people who desegregated Central High School are the ones who stole the American dream. And that relationship between an affirmative claim and an explanation of failure is a really important way in which we have misused race. That is, we are blaming people of color for the fact that white people, poor white people, are not benefiting from working hard and playing by the rules. So part of the turn to racial literacy is an effort to understand what it would take to educate the American people, not just to what happened in Central High School, but to the way in which our American dream narrative is not only incomplete, but misleading. Because it has no explanation for failure, except as the whites in Little Rock in 1957 understood, except in terms of identifying the people who are stealing the American dream from the otherwise good people of the country. So in that sense, it's very polarizing. The work of the American dream is polarizing because it doesn't have an explanation for failure other than an explanation for or a justification of racism. So what's the alternative? This concept of racial literacy. And the idea of racial literacy is that we really need to understand the way in which race matters, not just for people of color, not just for Latinos or for blacks, but it matters for poor and working class whites too, because it becomes an explanation for their failure in multiple contexts, that somehow the American dream narrative is being denied to them because of affirmative action, because of other policies that are trying to compensate for years of and a history of inequality. And so it's that contradiction or that internal conflict that we would like to emphasize in the context of the relationship between race and power, so that the people with power basically use race as an explanation for the failure, or at least the inadequate success, of all of the other good people of the United States.
And I want to put a little bit of a twist on the what happened in Central High School, because viewed from a slightly different perspective, what you viewed through the perspective of, say, hypodescent. Right? The minute you permitted black kids to attend Central High School, right, even though they were a substantial minority in the high school, it devalued Central High School. Didn't make it into a black school as such, but it made it into a less valuable school. So the white children who were required to continue to attend Central High School understood it not just as allowing new kids to come into our school and to share the resources that we had at Central High School, but the requirement that we now be forced to attend a school that was somehow less valuable, less good, a black school. And you see that replicated again and again. And what it's about, and one of the things that Professor Guinier and I talk about when we talk about race and using the idea of racial literacy, is to, first of all, try to get away from phenotypic definitions, right? Try to get away from mere descriptive definitions, even get away from the binary definitions of whiteness and blackness, but define blackness as a social position against which you define yourself. So that the farther you are from that social position of blackness, regardless of what color you are, the whiter you are. So that blackness then becomes a signifier of what you don't want to be. And it means that you can be black, and one of the things that political race, which is an idea that I'm going to develop now for the next couple of minutes, one of the things that political race allows you to do, which is that it allows you then to see blackness, or race in general, but blackness in particular, as a diagnostic. That is, if you look at social institutions and you say, which of these social institutions are not working for people you define as black, the chances are good that they're not working for other people as well. And so the task then becomes to identify those other people for whom these institutions aren't working. And once you undertake that task, then you understand that what it can allow you to do is to figure out who your political allies are, who you might link your fate to, who you might sit with, stand with, walk with, to challenge the way these institutions are working. Whether you're doing it for education, whether you're doing it for criminal justice, whether you're doing it for voting. And we can take any of those three institutions, we can take any others, right? We can take any of those three institutions and push it through the lens of this idea of race as a diagnostic device to ask what is dysfunctional about any particular institution. So that what political race then allows us to do is to start to develop a new lexicon of race, a new way of talking about race. And one of the ways it allows us to talk about race is to see those people who are functionally black, though they wouldn't be phenotypically defined as black, when they are suffering from the same dysfunctions, social, institutional dysfunctions, that are bedeviling people we phenotypically define as black. But this idea of blackness being a thing you want to separate yourself from, right, means that you want not to be an ally with those people who might actually help you change the institutions, not just for people who are phenotypically black, but for you as well. So the critical idea then of political race is that it asks, as a political project, right, who do you link your fate with? Who are our natural allies? And by identifying those who ought to be our natural allies, I realize I spoke too soon, right? Who ought to be our natural allies, you can start to decenter the whole idea of race as it is conventionally understood. Not to say that it doesn't have real meaning in other contexts, right? But certainly it has no specific fixed meaning. It has a political meaning, and you've got to use that political meaning as a way to organize resistance to its concrete effects. Now, what we'd like to do is to turn to some specific examples, and I'll give a simple one, and then we'll turn to the Fisher case and talk about affirmative action in Texas as a conclusion to this idea of celebrating Brown, right? Because Brown should get us to the point at which we can talk about affirmative action as a way to produce equality for many people in access to educational opportunities. But I want to go back a few years, back to 1996. And there was a case called Hopwood against Texas, in which the consideration of race was in higher education admissions was prohibited. The then Attorney General of Texas extended that reading to prohibit the consideration of race in all public decision making. So there was a great panic on the part of those people who had depended upon affirmative action, and great celebration on the part of those people who thought affirmative action was always illegitimate. But as people worried about how we might keep the University of Texas integrated, they were worried about a couple of things. First, they were worried that the University of Texas, and this is an important idea because it's an important idea for you to think about all institutions of higher education and where they fit. But in Texas in particular, the University of Texas is a gateway institution. So when you look at the leaders in politics, business, medicine, law, when you look at the social leaders throughout Texas, the one thing they have in common is a relationship to the University of Texas at Austin or Texas A&M. So if you resegregate A&M and UT Austin, you're not just resegregating those universities. You're resegregating the institutions that feed from these universities. So a smart woman from Kingsville, Texas, named Irma Rangel, who was a complete character, right, came up with this idea, which has come to be known as the Texas Top 10% Plan. And her idea was now that all students who graduate in the top 10% of their high school class are eligible for automatic admission to the flagship universities of the state. Now, a lot of people turn to this as a panacea, but it only would work in Texas because Texas is the third most segregated state in the country. I won't name the other two, but I leave it to you to guess which those ones are. It's not California. So the people objected because, wait a minute, they said, a kid from Del Rio who's in the top 1% of his class is not going to be as well prepared as a kid from Alamo Heights who's in the bottom 1% of his class. It's just not fair to these kids. And the problem, of course, is that there was a state constitutional obligation to equalize funding in public schools. So IRMA's response to these objections was actually pretty simple, which was, wait, so we in the legislature haven't done our job, and because we haven't done our job, we're going to punish the students? This is like whipping somebody else for your sins. So she said, you want equal public schools? Equalize them. In the meantime, they get to come to UT. But the other thing that happened, and then I'll turn it back to Professor Guinier to talk about the Fisher case. The other thing that happened was, and this is how political race works, right, is it did allow students from schools who would normally not send people to Texas to come to Texas, but it didn't pass because the Mexican-American legislators and the black legislators in Texas passed it. It passed because what IRMA did was to reach out to those rural Republican legislators in Texas and say, you know what? Nobody from your district has ever, in the history of the University of Texas, attended UT Austin. Isn't that a shame? Isn't that a shame? And they were suddenly aghast. And so it passed by one vote. And the one vote was a rural Republican from West Texas who stood up and said, you know, my constituents have been paying for this university for 120 years. I think they ought to go there too. So now they are. And now there's buy-in from all over the state at UT, right? But the other thing, and one last thing about political race, right, is people in UT, and I can see it, I was in upper administration at the time, we were worried that, oh my God, these kids are going to come and they're going to flunk out. So we said, what causes students to stay in school? And it turns out that one of the things that binds people to schools are small group experiences in the freshman class. So what we did is we created the possibility for every incoming freshman to have a small group experience. So the fact that the 10% plan was going to keep Texas integrated, class integrated more than race actually, right, in a way forced the university to make the freshman experience better for all students. And so what happened then? Well, what happened was the persistence rate increased. And persistence is just the rate at which kids come back for their sophomore year. What happened then? The four-year graduation rate improved. So as you improve the four-year graduation rate, more opportunities are made for people to come through UT. So not only are you expanding the pool of people who can come to UT, but you're increasing the number by the rate at which they come through. So the idea of black people from Houston and Dallas and Mexican legislators from Dallas and the Valley and the rest of Texas joining with the rural conservatives led them see what was wrong with how higher public education in Texas was being rationed. And that's one of the insights that figuring out who you ought to link your fate with can show you. Now it turns out that the 10% plan is, of course, the reason why affirmative action might be outlawed at Texas again, because it might be too effective, right? But Professor Guinier will talk about the Fisher case now, and then we'll conclude, and we hope to open it up for conversation from David and Professor Palumbo Liu and the rest of you, I hope.
So going back to this idea of racial literacy, I think it's helpful to situate the Fisher case in its historical context in particular, because what people have not emphasized, this is a case in which a white woman whose father had gone to UT and one of her siblings had also gone to UT felt that she was entitled, like her family members, to go to UT, and she was not admitted. And so her solution was to sue the University of Texas, claiming that she was not admitted because she's white. Now, there are a number of things that you have to consider in even approaching the questions raised by the Fisher case. One is, Texas is different than all of the other states where questions of affirmative action have arisen. For example, the Bakke case was in California, Washington v. Davis was in the state of Washington, the Grutter and case was in Michigan, right? Those were all states that did not have a history of being part of the Confederacy during the Civil War. Texas, however, is different. Not only was Texas involved in the Confederacy, but some of the people who were part of the Confederate Army, such as a gentleman named Colonel Simpkins, decided after they had lost the Civil War that they really hadn't finished the Civil War. So he and his brother went, or his cousin, went back to Florida, where they started a Ku Klux Klan organization and proudly killed 25 black people during their administration of this Ku Klux Klan organization in Florida. But then after killing all of these black people, they felt it was time to go back to Texas. So in 1899, Colonel Simpkins returns to Texas and boasts about his efforts in Florida, and it earns him a job as a professor at the University of Texas, where he proceeds to teach until 1929. And every year, he would give a lecture about his experience as a member and leader of the Ku Klux Klan to a packed house every year from 1899 till he died. And it was such a popular speech that they had it printed and was available to people who wanted to read it when he was not available to recite it. Now, this is a state where we also have to remember it was not just Colonel Simpkins who was a problem, but it was also the fact that although it was now remained part of the Union, it still did not want black people to participate in democracy. So it made it very difficult for blacks to register and vote. And one of those black people was a very determined person, Dr. Nixon. And he sued twice. Both times his cases went up to the Supreme Court of the United States. He was denied the right to vote in the Democratic Party primary, and the argument was that the Democratic Party primary is not a governmental institution, so therefore the Constitution doesn't apply. That's the argument. But in a unanimous opinion by Oliver Wendell Holmes, who, by the way, had fought in the Civil War for the Union, and who then became a lawyer in Massachusetts in the 1860s at the same time that the 13th, 14th, and 15th Amendments were being passed. And he writes a unanimous decision saying that what Texas did was a violation of the 14th Amendment. That didn't stop them, however, because Dr. Herndon still couldn't vote, even though the particular intervention had been declared unconstitutional. So his case went back up to the Supreme Court 5 years later, and then Justice Cardozo, writing for the majority, said once again that the 14th Amendment was designed to protect black people, that was a really important element of the 14th Amendment. Now, the reason I am emphasizing that is because the Supreme Court today has a very different interpretation of the 14th Amendment, using, supposedly on behalf of some of the members of the Supreme Court, the argument that they are relying on terminology and on events as of the time that the particular event happened. And yet here you have an event that is the 14th Amendment, where Justice Oliver Wendell Holmes is alive, he is well, he becomes a lawyer. He then writes an opinion in 1927 determining that the 14th Amendment was specially adopted to protect the Negro. And then you have a Supreme Court in the 1990s and 2000s saying, and here I'm quoting the Chief Justice, John Roberts, that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. In other words, stop thinking about race and move on, right, with your life. And he relies on the 14th Amendment, the same amendment that Justice Oliver Wendell Holmes had said was designed to protect the Negro, is now being used to say the way you protect the Negro is not talk about anything that's happening to the Negro, at least not here in my court. Now, the reason that I'm going into such detail about those two Supreme Court decisions is because Texas had a history of discriminating, right? So it was not just in the context of voting, it was also, as Professor Torres talked about, in the context of admissions to schools. And once Brown versus Board of Education was decided, it realized it was going to have to change in some way. But before it initiated any such change, it decided that it had to name a new dorm that they had just finished building right after the Brown decision in May of 1954. And within 6 weeks of that decision, they had decided that they would rename this new dormitory after Colonel Simpkins. So you had a dormitory named after the colonel, whose great claim to fame is that he had been head of a racist group, the Ku Klux Klan, and proudly claimed that he was responsible for the death of at least 25 black people in Florida. And this is the person they're going to name the dorm after. And when Abigail Fisher filed her lawsuit, Colonel Simpkins' name was still on the dorm. When the lawsuit went to the district court, Colonel Simpkins' name was still on the dormitory. It took until 2012, right? In other words, a year, well, or actually 2010, when a historian, Thomas Russell, wrote about Colonel Simpkins and the role that he had played, and outed Colonel Simpkins, whose bust was still in the library of the University of Texas, and the law students would still come to the bust before they were taking an exam and rub the head of Colonel Simpkins for good luck on their exam. Now, this is the context in which we're saying Texas is different than the University of California, than the University of Washington, University of Michigan. Nonetheless, we have a court that is likely to rule that Abigail Fisher was unfairly discriminated against because, after all, Justice John Roberts said in another case coming out of Kentucky, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. In other words, don't notice race and all will be well. Now, I don't want to go into too much detail about the Fisher case, but I do think that it's important to emphasize what Professor Torres was saying in terms of the 10% rule. Because many people think that the one person on the conservative side of the court who might try to come up with a compromise between the liberal members and the conservative members is Anthony Kennedy. And Anthony Kennedy loves the 10% plan. He loves the 10% plan because it is not talking about race directly, it's talking about race indirectly, right? It's basically building on the racism that already exists which then leads to the segregation of people based on race. And the fact then that they are going to a predominantly black or predominantly Mexican school means that the top 10% of that school is more likely to be black or Mexican, and therefore that's a fair and just way of making the University of Texas available to everyone. The problem that Abigail Fisher raises is that they also have, in addition to the 10% plan, a program where 1,200 students are admitted to the freshman year using holistic review. And holistic review is very much what some place like Stanford or other universities uses, in that you're looking at the whole person. You're not just looking at the fact that they may be poor or rich. You're not looking at where they went to school and assume that if they went to a school that wasn't as competitive, that therefore they're not prepared for the University of Texas. There are lots of ways in which the holistic review works. But the key point that you need to know about the Fisher case is that there were 216 students who were black or Latino who made it under holistic review into the University of Texas. Okay, and this is in 2008. And that's 216 out of 1,200. Okay, so most of the students who came in through holistic review did not come in or were not the beneficiaries of it because of their race. But it gets even more precise. Of the 216 black or Latino students, 183 of them got in based solely on their test scores, right? On their SAT or ACT test scores. So the Fisher case is about the fact that the University of Texas admitted 33 black or Latino students to the freshman class in 2008 in a state that is at least 11 or 12% black and close to 40% or 38% Latino. And we're arguing about 33 students out of 1,200 who came in using holistic review, meaning everything about them was considered relevant in terms not only of their race, but their parents, whether their parents had gone to college, what they had done in their spare time, had they shown leadership, etc. So the Fisher case is therefore a really important case in talking about what's the role of race going to be in this country if, as many people predict, the Supreme Court is basically going to overrule Oliver Wendell Holmes' claim that the 14th Amendment was designed to protect the Negro and determined that the 14th Amendment was actually designed to protect Abigail Fisher.
So, my turn? Or were you going to?
I have a little bit, but
No,
go ahead, because time's short, so let's turn it over to you, and then I'd like to get the people involved.
Yeah. I have about 5 minutes, and then I have 3 questions for you.
Okay.
And then we'll open it up. I wanted to begin by just pulling 2 things out about racial literacy. One is that you say racial literacy is a different understanding of the meaning of race and its relationship to power. And I think that this is something that's stressed throughout your books and your works. It's the importance of looking at race and what happens with race, not simply as individual phenomena, but rather as deeply attached notions of power and differentials of power. The other quote I have is that it involves how an individual experiences power and then connects that to the experience of others. Right? So it's, again, not just individuals, but also the idea of trying to see how one's experience of power might be related to others. And I would just add, connects in an introspective, skeptical, and critical manner that doesn't take for granted the point of view of the person involved. In other words, you just don't say, well, I'm going to make this connection, I can relate this way or that way, without inspecting your own premises that go behind that. And I think this is a key pedagogical element in your writings, right? What goes on in the classroom is precisely this kind of weighing of results. And I just wanted to attach that to one element of the Fisher case, which hasn't been mentioned so far, but I think is really interesting for a humanist. And that is this, one of the problems, as I understand it, is determining critical mass. That it's a double-edged sword in that if the top 10% practice works, how do you know it works? Well, what's your measure? And when you start taking measurements, you're getting dangerously close to quotas. So both sides are trying to figure out at what point have we reached an adequate solution to race. And it cannot be numerical. And of course, as a humanist, I love this, right? But what it then becomes hinged upon is something else that Lani Guinier wrote about in her brief, which is isolation and experience. And this gets back to this idea of experience that I talked about a second ago. And she writes, UT's pursuit of classroom diversity remedies discrimination and its present effects because it reduces racial isolation and consequently promotes robust intellectual exchange in the classroom, right? If the point and the value of diversity is to have something different going on in the classroom, you have to have people from diverse backgrounds feel free to contribute those experiences and not have this chilly classroom climate. And she says, see Gruder 539 US at 330, educational benefits include the livelier, more spirited conversations possible when students have the greatest possible variety of backgrounds and cross-cultural understanding can develop out of robust exchange. She continues, more than 50 years ago in the landmark case challenging segregation at UT, the court recognized that free intellectual exchange across color lines is a critical and tangible element of equality and equal education. But then when you look at the transcript of the court hearings, you find that this issue of critical mass and of isolation gets bounced back and forth. And I can't resist the opportunity to channel Supreme Court justices. But this is Mr. Rain who's arguing for the plaintiff. In order to satisfy Gruder, you first have to say that you are not just using race gratuitously, but it is in the interest of producing a critical mass of otherwise underrepresented students. And so within the Gruder framework, the first question is, absent the use of race, in other words, using the top 10, would we be generating a critical mass? To answer that question, you've got to examine the context of the so-called soft factors that are in Gruder. You know there's this, how do you know there's isolation on campus? Do members of minorities feel that they cannot speak out? Justice Sotomayor, the one social studies that this university did said that minority students overwhelmingly, even with the numbers they have now, are feeling isolated. So why isn't that even under your test? We can go back to whether substantial evidence is adequate, is necessary or not. Why does their test fail? Mr. Ryan, well, the survey was a random survey. It's not reported in any systematic way. They evidently interviewed students, and that was all about classroom isolation. So we're talking about the silencing of students, and Lani Guinier's brief talks a lot about evidence from students themselves that is not factored into this. It's been dismissed because the study is too random. It doesn't hold up. Scalia, why don't you seriously suggest that the demographic makeup of the state has nothing to do with whether somebody feels isolated? That if you're in a state that is only 1% black, that doesn't mean that you're not isolated so long as there's 1% in the class. Mr. Ryan, certainly racial balance. Justice Scalia, I wish you would take that position because it seems to me so right. Mr. Ryan, Justice Scalia, see, they start feeding him things. Racial balancing is not a permissible interest, and this court has constantly held not a permissible interest. And that is something we certainly agree with. Trying to respond to Justice Sotomayor and the framework of Gruder, what you're looking at is, does this person, a member of a so-called underrepresented minority, it's a concept we don't necessarily accept, it's a Texas concept, are they isolated? Are they unable to speak out? And I think we've always said that if you have a very large number, as Texas did in 2004, when they ostensibly made the decision to reinstitute race, they had 21% admission percentage of what they called underrepresented minorities. They also had about an 18% admission rate of Asian Americans. So on campus, you're talking about 40% of the class being minorities. Justice Breyer, but the test is, in your opinion, I have to write this in the opinion you say, the proper test of critical mass is the minority isolated, unable to speak out. That's the test. Wasn't it in Grutter? Wasn't it? Ryan, yes, expressly said in Grutter. I won't go on and on about this, but they volley back and forth for several exchanges about what counts as critical mass and how much evidence these witnesses of isolation, how much their testimony counts. So it's a vicious circle. You know, if you don't feel their testimony counts because it's a random case, then you're never going to be able to address the critical mass question. So that to me is a fundamental issue of the idea of connecting individual experiences to collective experiences of power, and then how that translates into actual legal action. So my three questions are this. They're very simple. One is, in the Fisher case, or in any other case you want to comment on, what sorts of racial literacy would you like to have seen in place? Second, what kinds of racial illiteracy do you see there? And third, and I can't help asking this question, what's your prognosis for Fisher? So.
One of the racial illiteracies is the one that Professor Guinier talked about, which is understanding that the context within which the use of affirmative action arose is radically different. Because, I mean, you're talking about one of the states in the Confederacy where the UT system itself, unlike, say, the UC system, but the UT system itself was cobbled together out of a dual system that had existed until segregation was outlawed. So you have a series of campuses that are white campuses and black campuses and some de facto brown campuses pulled together and constructed and created into something called the University of Texas system. So the system itself, the genealogy of the system is rooted in segregation. So what racial literacy would have done is it would have said that talking about the way race matters in Texas is different than the way it matters, say, in California, and it matters largely because Texas has this history that's got to it's got to confront. I often said that it's actually Sam Cunningham who integrated the University of Texas. And most of y'all don't remember Sam Cunningham, but he played tailback for USC. He went and they played Alabama, and USC beat the tar out of Alabama. Alabama, of course, had an all-white team. USC had an integrated team. After that beating, Bear Bryant saw the need to maybe reach out to a wider, more diverse, let's say, recruiting class. And Texas, which holds the distinction of having the last all-white team to win a national title, suddenly found itself in a competitive disadvantaged position in the Southwest Conference. And it too felt the need to, in 1971, to integrate its sports teams. Right, so that history makes race matter differently. I don't know if you want to take the question of the prognosis. I mean, it's a difficult case, right? Because the 10% plan only applies to undergraduate education. It doesn't apply to graduate and professional education. So even if Fisher wins her case, the question is whether a holistic review would be permitted at the graduate and professional school level, right? Because you don't have the 10% plan that would produce the race-neutral alternative that would create the critical mass of diversity necessary to achieve the educational goals that justify the plan. I don't know.
This question about racial literacy, and you asked what sorts of racial literacy are there, or
Would you like to have seen in practice
by the Supreme Court or by the University of Texas?
by the court in these kinds of,
Oh, can I
or is there any room for it? Or?
He's giving me an answer, but I don't hear it.
No, I'm sorry. Okay. Okay. One thing you'd like the Supreme Court to say is, okay, let's imagine any application. Okay, let's imagine any application. And what we're going to do is we're going to take this application and we're going to strip it bare of any possible thing in this application that might allow us to understand or apprehend that the person who's applying has a particular racial experience. Okay? And that's the only way we can be sure that admissions officers are only looking at the objective criteria. And of course, we'll still call it, holistic review. But if you strip all of those things, so let's say we strip out all things about gender, right? Let's say we strip out we don't know whether it's a white person, a white woman, a black person, a black woman, a Mexican woman. We don't know any of this stuff. In what sense is that review holistic? Since what you've done is you've reduced them to a kind of, I don't know if you remember those old cartoons that would show fluoroscopes, right? Where, that guy would stand behind the fluoroscope and just be the skeleton, right? That's what the review would be like, right? You're setting these people behind this fluoroscope. And, well, I like that skeleton. Okay, next one, right? But it devalues and makes a mockery of the idea of considering the whole person as an applicant, because the lived reality of all of us form who we are, and the way we experience race through our lives, whether you're white, black, or Asian, Mexican, has an impact on the way we experience life and has an impact on how we present ourselves to the world. And if you strip all that out, you might be doing some kind of review, but you're not doing holistic review. I guess that's one way I'd like the court to recognize or appreciate race.
I guess another way of thinking about this is to use race as a proxy for other kinds of misleading and yet significant elements of the admissions process, and that's what I'm really referring to as wealth. That in some way it's okay to measure the wealth of various people and admit students based on their wealth or their, quote, class, but it's not permissible to consider their race, presumably because their class is something they earned and their race is something that they were unfortunately birthed with. But that seems very, it's obviously asymmetric, but it seems worse than that, because race is a way of avoiding the language of class. And so by looking for holistic review and assuming that knowing, so-and-so's parents made $1 million and then they're perhaps likely to contribute to UT, and so we should invite the student to participate in the school because he or she will bring their parents. These are all qualities of the individual that have very little to do with are they, quote, the most qualified, except in the context of fundraising. That becomes, a prerequisite for qualifications. And the reason that I'm mentioning that is the University of Texas has a mission statement. It's not just why are they admitting people to the school, but what is the purpose of the school? And the mission of the university is to train future leaders of the state. So you definitely want to have a representative group of potential future leaders. The idea that this school's mission is to train leaders, but we're only going to allow a certain percentage of certain ethnicities to come into the school because we are using proxies for their social status, and the proxy for their social status is these SAT, ACT, GRE. I happen to have had the opportunity to look at the LSAT of students at the University of Pennsylvania Law School, just as an example. I was looking at it for a reason. I'm giving it to you simply as an example. And we found that if you knew someone's LSAT at the University of Pennsylvania Law School, you would be able to predict their law school grades 14% of the time. Meaning 86% of the time you'd be wrong. That's based on 4 years of data that includes LSAT as well as first-year grades. You say, oh, well, maybe it does better second year. So you look at the second-year grades, you look at the same LSAT score, it predicts 15% of the variance in second year law school, meaning 85% of the time is wrong. And yet, we're so preoccupied with what we consider these neutral tests. What is it that the LSAT is, or the SAT is really telling us? It is really a wealth test, not a test about how you're going to do in school. And we have allowed wealth to be a proxy for merit. And apparently, at least one could argue, part of the reason we don't want to intrude race on that bargain is because we think wealth alone, in its disguise, will do the heavy lifting, because despite the mission that we want to train a diverse group of leaders, it's a school. They need people, as Professor Torres said, who can come in and pay full fare. So they're claiming that they're committed to excellence, but they're using proxies for excellence that are really about proxies for success, and proxies for success based on what people have earned or inherited during a period when blacks and Latinos couldn't even participate in the political process, much less come to the University of Texas.
One last point on that, and one of the reasons Texas is different, right, is that if you read the history of Texas, what you realize is that even banks gave out differential credit terms based on your race, right? So that if black farmers, right, had less credit to get to farm, right? So the capacity even to accumulate wealth was different. Anyway, that's
Okay. We have a few minutes for questions, so. Gary.
My name's Gary Segura. I teach in political science here, and I really appreciate your comments. I want to swim a little upstream and say that while I appreciate the idea of racial literacy as a way of rethinking for the mass public what the various institutional and social forces are that create racial inequality in the United States, and I do firmly believe that racism is institutionalized and not just simply a function of bad individuals, I want to push back a little bit and say, aren't some individuals bad? And let's not let them off the hook here. And specifically talking about the court. And what made me think about this is David's question. About what racial literacy might do for the Supreme Court. So if we look at Justice O'Connor's decision in Shaw v. Reno, she said that a redistricting scheme in which whites were still advantaged relative to their numbers was a violation of the Equal Protection Clause of the 14th Amendment. And in so doing, she followed that very perverse interpretation of the legislative intent of the 14th Amendment, which was clearly designed to protect African Americans. And at the same time, she found that whites were discriminated against even when they were advantaged. So it's hard not to look at that and just take a step back and say, these are arguments about process, but really the preferences are formed about outcomes. That is, there's a set of white racial actors who are acting in every opportunity to preserve the racial status quo, and using a lot of process arguments to strike down the various processes that got us there. First quotas, then a holistic review, then the top 10%. But really what the argument is about is about outcomes, and the white elite wishes to preserve the status quo. So aren't there some just bad actors too?
Yes.
The answer is yeah, happy. Yeah, right. Indisputably, indisputably. Bad actors are to be found everywhere.
But I guess my question back to you is, why are you focusing on just those quote unquote bad actors? I mean, it's in other words, access to higher education has become a competitive goal, and it is a competitive goal that some families can achieve because they can purchase it, right? And then there are other families or contestants, applicants, who have to, quote unquote, earn it. My view, though, is to start in a different direction, which is what's the mission of this institution? And as Professor Torres said, one of the elements of the mission statement at UT is that they're training a diverse group of leaders who will be able to solve the problems of the next generation in Texas. So if that's their mission, then in my view, they should be developing criteria that are going to meet that mission without regard to necessarily SAT scores. There's nothing in their mission statement that says we want to have people with high SAT scores. We're presumably using that as a proxy for your capacity to learn or for what you have learned, when if you look again at the SAT and peel it back, you see that it's actually a proxy for wealth, and that they norm the SAT and the ACT based on the performance of upper middle class white students. So there are all kinds of proxies that are being used. They're just focusing on race because they don't like the outcome, right? It's not that there's something, I mean, why is race so different given the fact that race has been a proxy for not just wealth, but for what school you get to go to, where your house is, in the lives of even the current generation?
One point, and then is that when you look at the people, the 10% plan actually is a wonderful natural experiment, because even though it's not used for admissions, students are still required to take the ACT or the SAT. And the students who would not have been admitted under normal affirmative action plans, but are admitted under the 10% plan, are outperforming those students who had SAT scores up to 300 points higher. Right? And so what it led the admissions officers at Texas to ask is, we thought we knew how to construct a class, but there's something about these kids who are succeeding that we didn't know. Let's figure out what that is, and maybe we can construct a better admissions process.
I actually think that's a wonderful insight, that in fact, one of the great aspects of your talk is I'm left without any firm ground to stand on whatsoever. Any single rationale or decision criteria quickly gives way to its flaws. Okay, let's just do merit. No, wait, we can't do merit because the people who are most meritorious were gifted by class and privilege and wealth. We don't want that. Let's do potential for the future. No, we can't, you go on and on and on. There's no safe ground to stand on. And I think that's actually a wonderful thing, because there is something inherently holistic about, let's say, selecting and grooming a cohort of leaders for the future. It can't be reduced to a single formula or a set of criteria which are purely and objectively measured. But then we go to the other side and say, gee, why do we have any of these efforts to modify the choice of thoughtful people? Why do we have affirmative action? Why do we have to integrate? Why can't reasonable people who are in power simply create an optimal mix of candidates? And it's because we don't trust them. If the only reason why there has been efforts in the legislature and in the courts to change the selection criteria that naturally occurs is that we collectively don't see that those criteria leading to a just and fair solution. So we try to modify those criteria in kludgy ways, none of which is perfect. And I think
Excuse
it
me,
goes
sir.
back.
I'm just going to, because we are short on time, I want to know,
Sure.
is there the question? Can we call for the question right now? What is
Yes,
the
I'll
question?
frame it as a question. How can we reconcile your remarks against a paradigm of the people who are making the choices are not trustworthy? And how do we build more trustworthy selectors without resorting to kludgy rules?
Yeah, that's yours. I'm kidding. The short answer is we have to be vigilant about democracy, first of all, where we're talking about public institutions, right? So we have to be vigilant about the processes by which the people who are selected to represent us are selected. So it's tied to that process as well. It's also where, for instance, one of the things you're looking for is a diverse classroom experience. You might say, what process is it going to take to produce a diverse classroom experience? So at Texas, even with the 10% plan, 80% of the classes with 25 or fewer students in it every semester have one or fewer person of color in the class. Right? So what the people at the University of Texas said is, that's not enough for a robust discussion, for people to not feel like every time they speak, I'm going to represent all Mexicans. Every time I speak, I'm going to represent all black people, right? So we need to do that so we can trust. We want people to produce their evidence, right? But for those people who think that there is something to having a diverse classroom setting for an improved educational experience, we can test them, we can trust them on that, but we have to test them, and we have to continue to ask for evidence, I guess. But we also have to continue to keep our eye on democracy.
So I'm going to have to play the timekeeper here. Unfortunately, we're at the end of our time here, but I would ask you to join me in just thanking our guest speakers and our moderator today, Professors Guinier, Torres, and Palumbo Liu. I mean, thank you for this discussion. It was very rich. Thank you. And before you leave, I just wanted to mention two things. First, I want to acknowledge the Kieves who are here, because they are the namesake of the lecture. Ann and Lauren Kieve, who were not here, I'd like to just say thank you. Please stand so people can know you. They've endowed this lecture, which is, as I say, thank you so much for your generosity. And there's a reception. There's a reception right out here in this room here, out to the back of the room. So please stay around. I'm sure some of you have questions. Our guests will be here for another half hour or so, and then I'll whisk them off to dinner. Thank you for your time. Thank you for coming, and have a very good weekend.